Stanford University. They are both authors of How to Steal a Presidential Election, which is available for pre-order now. Welcome, Matthew.
Hi, nice to be here.
And welcome, Larry.
Great to be here.
So the book is How to Steal an Election. First, we're going to talk about these faithless electors. So talk to me about what that is and what it means in the process of stealing elections.
Yeah, so since the beginning of the Republic, there have been electors who've been chosen and then decided to vote in a way contrary to how people expected. The very first one of these was in 1796 with a guy named Sam Miles, who was chosen to support Adams in Pennsylvania. But when the votes came in, it seemed like Jefferson actually had won Pennsylvania. So he decided to vote for Jefferson. And that infuriated people because he was selected for the purpose of voting for Adams, and he changed his vote and voted for Jefferson. Nonetheless, when the 12th Amendment came along, which was the only major amendment of the Electoral College process, they didn't change that process, giving electors their freedom to vote as they wanted. So throughout history, you've had electors deciding to vote contrary to how they were pledged. In 2016, this became quite a serious issue because a bunch of electors, after seeing that Donald Trump had not won the popular vote, even though he had won the Electoral College vote, decided to get together and try to persuade enough Republican electors to vote for somebody other than Donald Trump so it could go to the House of Representatives and the House could decide to vote however they wanted. They could vote for Donald Trump. They could vote for another Republican. They could, in principle, have voted for Hillary Clinton, but that obviously was not going to happen. So they tried to rally people. They failed to rally enough Republicans. They rallied a couple. And then after the election, a couple of them were fined. And I actually took the case to the Supreme Court to decide whether this tradition that had existed since the founding of electors being allowed to exercise their judgment was actually constitutionally protected or whether states could overturn it. I thought it was pretty clear it was constitutionally protected, but 9-zip, the court went the other way.
So that's so interesting to me because I thought it was constitutionally protected.
Yeah, so did I. In 2020, I guess it was July of 2020, the Supreme Court decided 9-0 that, in fact, states could control how electors could vote. So this creates two real problems in the upcoming election. One problem it creates is just that not all states actually control how the electors can vote. So there's a bunch of states still where the electors are free to vote however they want. And so in principle, you could imagine candidates persuading electors to switch their vote. It's never happened for an illegitimate reason in the history of the Republic. There's been legitimate reasons you could agree or disagree with them, but that's still an open question right now. But the second more dangerous issue, which the Supreme Court case created, is that you could imagine a legislature after an election deciding it didn't like the results of the election or didn't have confidence in the results of the election. What they can't do at that point is pick a new slate of electors, but what they can do, we argue, under the reasoning of the Supreme Court case, is basically tell their electors how they must vote. So the electors could have been elected to vote for Joe Biden, and then the legislature passes a law that says, we actually think the real winner in our state was Donald Trump, so we direct you to vote for Donald Trump. And the Supreme Court upheld the procedure that said that if they don't vote the way they've been directed, they can be removed and replaced with somebody who will. So this is a huge hole in the electoral system that's been created, and there's no obvious way to fill it unless the Supreme Court finds a way to reach out and clarify or restrict the scope of their decision.
So this is different than what happened with Trump and his slates of fake electors. Can you talk a little bit about that?
In the lead up into the 2020 election, Trump obviously was fighting in every single court he could to get the results in key swing states reversed. And it's just an unfortunate feature of our electoral college system that the electors have to vote on a particular day, and that day might actually be before the results in a state are decided. So in 1960 in Hawaii, the election seemed to go for Richard Nixon. Then there was a recount ordered, and that recount and certification didn't occur or didn't complete until after the electors had to vote. So what the Democratic electors did, as well as the Republican electors, is they both met on the day electors were supposed to vote and cast their ballots. The Democrats for Kennedy, the Republicans for Nixon. And then when the election was finally resolved, the slate of electors for Kennedy was urgently sent to the Capitol. The Nixon ones had already been sent. And Nixon was the vice president. And Nixon said, well, it's kind of an odd situation, but not setting any precedent. I'm going to recommend we count the votes for Kennedy, and Kennedy's votes were counted. The Trump electors and the lawyers for Trump, Ken Chesebro most directly.
Everyone's favorite.
So they knew of this precedent. Chesebro was urgently writing memos to states around the country saying that if you want your electoral votes to count, they've got to be cast on elector day. Now, in some states, that was completely bogus. Like New Mexico, the Trump campaign filed a lawsuit 15 minutes before the electors were supposed to vote to somehow create cover for Republican electors to vote, even though the state had been decided by more than 10 points for Biden. In other states, it was more open. The state of Wisconsin had an ongoing state court proceeding, which was resolved only 15 minutes before the electors were supposed to vote. At least a vote of the state Supreme Court was resolved then. But they still hadn't filed their motion for rehearing, so plausibly they had an ongoing chance that their votes would count, so they also met and cast their ballots. Now, all of these electors are called fake electors. I believe, and I think Matt agrees with me, that it's not fair to call all of them fake electors. If you genuinely believe the election is undecided, the only way your votes could ever count is if you gather and vote on elector day. It's just a flawed system. So if they genuinely, in good faith, believed it was an unresolved election, then it's a good thing they gather and vote. Because if they didn't, their votes couldn't count. This is one of the lessons that Ken Chesebro learned because he worked for Al Gore in 2000. And the lawyers for Al Gore made the incredibly stupid mistake of conceding that everything had to be resolved by what's called the Safe Harbor Day, which was days before the electors were supposed to vote. So the Gore electors actually never voted on Electors Day. They never cast their ballots. So even if somehow, the whole system had inverted and the recount had happened and Gore had won, there wouldn't have been any electoral votes to be counted on January 6th. So that's why Ken Chesebro was so keen to make sure the same thing didn't happen with Donald Trump. But obviously, Gore's claims for legitimate recount were stronger than Donald Trump's.
So, Matthew, I think we need to talk about John Eastman. You were a witness in that case. Can we talk about that?
Sure. So that's right. I was the expert witness for the State Bar of California in John Eastman's disbarment proceeding earlier this year. And so the principal issue that I testified about is the powers, or to be more precise, the lack of powers that the vice president has in the electoral count. The 12th Amendment, which is what governs our electoral college, says that the president of the Senate, who is the vice president, shall open the certificates in the presence of the Senate and the House of Representatives, and then the votes shall be counted. And it says that in the passive voice. And as a result of that passive voice, it doesn't say exactly who does the counting. John Eastman and others, including Ken Chesebro, advanced the theory that, well, actually, the vice president is the one who does the counting of electoral votes. And as a result of that, the vice president is the one who gets to resolve any disputes about electoral votes. So if there's, for example, multiple submissions of certificates from different slates of electors, Eastman advanced the theory that, well, it was actually Vice President Mike Pence who got to make the final decision about that. Now, the text doesn't fully resolve that issue one way or another. And so Eastman made a claim about history. He said that actually the original understanding of the Constitution going all the way back to the 1790s was that the vice president resolved disputes about this. And that was the basis of this fateful advice that he gave in a dramatic Oval Office meeting with President Trump and Vice President Mike Pence, where he was imploring Vice President Pence to exercise some unilateral constitutional authority to change the results of the election. Now, Vice President Pence ended up rejecting that theory, and he very dramatically, right before the electoral count started and the violence came to the Capitol, he released this public letter saying that he didn't believe that that was the right interpretation of the Constitution. And in this case, Vice President Mike Pence was right, and President Trump and his lawyers, Eastman and Chesebro, were wrong. And so the way that Eastman ended up in a disbarment proceeding isn't just that he gave incorrect legal advice. It's that he gave legal advice that had no historical basis whatsoever. So Eastman based his theory on the idea that in 1797 and 1801, there were vice presidents, John Adams and then Thomas Jefferson, who presided over electoral counts in which they themselves were then elected president. And according to Eastman, those vice presidents, Adams and Jefferson, actually resolved disputes unilaterally about electoral votes, about the validity of electoral votes. In 1797, it was about Vermont. In 1801, it was about Georgia. And according to Eastman, well, that's historical precedent. That shows that the way the founders imagined the Constitution and how this would work is that the vice president and not Congress would have the authority to resolve these sorts of disputes. Now, Eastman's history was flat out wrong. And so if you go back and read the records, it's absolutely clear that neither John Adams nor Thomas Jefferson resolved any disputes about this. Nobody ever suggested at the time that the vice president had this authority. And the way the process works from 1791 until today, Congress appoints these members of Congress as tellers, and the tellers do the counting. And this is still true. But John Eastman, used this misunderstanding of history to say that Vice President Pence had this extraordinary power. And it's worth stepping back for a second to imagine how radical that view would be, not just because it defies history, but also because it would create a system where the vice president would get to decide whether he won re-election. We sometimes gloss over the fact that John Eastman's advice to Mike Pence wasn't just that he could decide that President Trump would be re-elected as president. He was saying that Mike Pence could decide whether Mike Pence was reelected as vice president. And that violates a pretty fundamental principle of the rule of law that no man can be a judge in his own case. But that's exactly the theory that they advanced. And it's just completely unsupported by the history. And, it's really difficult to imagine that Eastman, that Trump would sit here today and say that Vice President Kamala Harris has the authority to decide the election on January 6th of 2025. And so I think that illustrates that perhaps they don't have the courage of their convictions.
So there is no there when it comes to Mike Pence changing the vote, huh?
That's absolutely right. There is no evidence at all. So there was no dispute about electoral votes that reached Congress during the electoral count in 1797 or 1801. And so there was no dispute to resolve. And after each of those electoral counts, exactly 0 people said anything. And so according to Eastman's theory, John Adams and Thomas Jefferson each unilaterally decided that they would be elected president. And after that, nobody said anything. Nobody in the opposing political party complained at all. And that's like saying that, well, if Mike Pence counted Trump and Pence as reelected in 2021, that there would be absolutely nobody, not a newspaper column, not an opposing politician, not the losing candidate. 0 people would have complained about it. And that's just completely implausible. And when there actually were disputes about electoral votes, which happened about a half dozen times in the 19th century. The first time was in 1817, then 1821, 1837, 1857, and then 1877, which was the most serious one. In every single one of those cases, it is absolutely 100% clear that Congress resolved the dispute, and the vice president played no role whatsoever.
What should be done to keep whoever wants to, though I assume it'll be Trump, from stealing this 2024 election?
The most important thing to address is the problem with electors, I think, because if the electors can be told to vote differently from how they were elected to vote, then that's an obvious, simple way for these rogue state legislatures to reverse the results. So it's pretty hard to imagine the Supreme Court addressing that question. I think one big thing to do is to begin to build out the understanding that this is possible, and we've got to resolve that this just is not allowed to happen. So that would be my first vote. Matt, what's your second vote?
My second vote is that the residual ambiguities and weaknesses in the Electoral Count Reform Act. So Congress did an extraordinary thing, actually passed election reform, a reform of the Electoral Count Act. And so prior to the Electoral Count Reform Act, the old ECA, the one that we had in place on January 6th of 2021, was catastrophically vulnerable to manipulation. A single governor defining, the outcome of the results in his or her state could potentially flip an election, and there was nothing that anybody could do about it. And so Congress did this extraordinary thing in December of 2022 that almost went unnoticed, given how significant it is, by closing a lot of those loopholes. But many loopholes remain. And so, there's still time for Congress to step in. I'm not overly optimistic that that's going to happen. So I think that we need to be prepared for the possibility that these residual loopholes in the Electoral Count Reform Act can be exploited. And how do we organize against that? Well, I think there are two things. The first thing that we do is that we start preparing the legal arguments that we're going to have to make in court. The 2020 election didn't go to the Supreme Court, but, as Larry indicated, there's, I think, a serious risk that there are going to be legal issues that do end up becoming so severe and potentially outcome determinative. So it goes to the Supreme Court. So we need to be prepared to do that. But stepping back from that, there's something that we election lawyers call the margin of litigation. And so the reason why Bush v. Gore was such an intensely disputed election, where, the election in New Mexico in 2020, where Biden had won by 10 points, wasn't, is because the difference was so big in New Mexico. And so we election lawyers talk about the margin of litigation as if it's not close enough that there are plausible, or at least plausible sounding allegations of fraud or misconduct or illegality. If the margin is just really, really big, then these disputes and these legal questions don't have enough purchase to create real risks. The most important thing that people can do is vote and make it so that the margin is outside the margin of litigation. And now in our new world where election disputes go beyond courts and they go to state legislatures and they go to Congress and they go wherever they can possibly go, making sure that that margin is large enough that no state legislature would dare do the things that we are talking about. If, Biden